It's one of the biggest gospel music festivals on the East Coast, and this year it features the biggest lineup ever. The Virginia Beach Gospel Music Festival, October 8th through 10 at the Sandler Center for the Performing Arts with Guy Penrod, the Booth Brothers, the Triumphant Quartet, Mark Lowry, Daly and Vincent, Brian Free and Assurance, the Martins, Jeff and Sherry Easter, the Hoppers, the Irwins, comedian Tim Lovelace, the Penny Loafers, and more. The Virginia Beach Gospel Music Festival, October 8th through the 10th at the Sandler Center for the Performing Arts. Tickets are available now. By phone at 877-392-9710. That's 877-392-9710. Online at imcconcerts.com. imcconcerts.com. It's a tsunami of gospel music hitting the East Coast. The Virginia Beach Gospel Music Festival. It's 3 days and 5 big sessions at the Sandler Center for the Performing Arts. For more information, go to virginiabeachgospelmusicfest.com.
Well, welcome to Justice for All. I'm George Yates, and we're going to be here for the next hour live here at, Premier Talk Radio, K-Talk 1650 AM. Thanks for joining us, 454-1650 if you want to give me a call. And we'll be here for the next hour with my show here. I'm a lawyer in Virginia Beach, and I've had this show now for about a year and a half. And if you're new to the show, you know that I will try to interview experts on this show every week. Folks who experts in their fields, and I figure, if I want to know something or learn something from them, I figure that maybe my listeners will get something out of it too. So that's what we try to do, is pick the brains of these experts and have them come on, and we'll all learn something from them. And we try to be as entertaining as we can, and we'll see where the whole thing takes us. My guess is that many of you folks listening out there today are 55 years of age or older. And if you are, this show is definitely for you. If you're under 55, there's still some things that you can learn, because these issues in today's show are not exclusive just to people that are in their middle ages or beyond. And of course, many people are way past the ages of 55 listening to my show. And so this show will be definitely for you, because the name of the book that we're going to discuss today, and my guest who wrote the book, the name of the book is 5 at 55. And if you out there are listening to this show and you don't have a will, or a healthcare proxy, or a living will, or a power of attorney, or what they call a digital diary, well, then you are not in possession of the 5 essential legal documents that you need to have by age 55. Now, this isn't an infomercial today. Don't get me wrong. I'm not asking you to come to my office and have me prepare these documents for you, although I probably can. I might want to steer you into the direction of an elder law attorney or someone that does specialize in that. We did have Jeannie Atkinson on our show several months back. She is an elder law attorney. Maybe I'll refer you over to her. But our guest today is Joanne Seminara, and she is the author, the co-author of 5 at 55. And she's will be with us in just a minute. I'll give you a little brief introduction to this lady. She's been an attorney licensed to practice law in New York and New Jersey for almost 3 decades. And she practices in the areas of elder law, estate and trust planning, estate tax, Medicaid planning, all that kind of stuff that affects elder folks. And of course, 55 is not elderly anymore. You think 55, you're just still working, and you're thinking about maybe going skydiving this afternoon. So just because you're 55 doesn't mean that you're packing it in. A lot of people don't even want to think about a will. Wait a minute, I'm not ready to die. I'm only 55. But that's what Joanne Seminara is going to be talking about today, and why these essential documents are necessary for folks that are starting getting into middle age before it's too late. So I'd like to welcome her to the show. How are you doing, Joanne?
It's a pleasure to be here, George. Thank you for the nice introduction.
Yeah, and listen, the name of the book is 5 at 55, and you say here are the five documents: a will, a healthcare proxy, a living will, the power of attorney, and a digital diary. So why don't we just start with wherever we want to go with this? So we've got an hour today. Everybody should have a will. And why don't we just start with the will? Why should somebody need to have a will?
Well, a will directs how you want to leave your property, to whom you want to leave your property, how it should be used by those people, perhaps, any restrictions you want to leave on how you leave it, and very importantly, can should appoint an executor and a few alternate executors to appoint the person who's going to manage the transfer of those assets from you to the next generation or to the people you choose to leave your assets to. Without a will, you're subject to the laws of the state. People may disagree about who should manage your estate. The court will decide who will administer your estate. It's often more difficult to get through the probate courts without a will, and there's a lot more opportunity for disagreement and strife among your family members or loved ones who will take according to the state law. So a will offers the opportunity for you to be very precise, to leave special gifts or bequests to those people you want to have them, and to really think about your legacy to your loved ones and be very specific about how you want to be remembered in connection with the transfer of your assets.
Okay, what is, and I think everybody knows what a will is, but these other things, right. What is a health care proxy?
A health care proxy is a document in which you appoint an agent to make health care decisions for you if you are unable to make them for yourself.
Now, we call that an advanced medical directive, too? Is that what...
We can call it an advanced medical directive.
That's what we
can call it a health care power of attorney.
Okay.
Here in New York, where I practice, we call it a health care proxy.
Okay.
You can name that individual, you put on that form their address and phone number and any contact information. It's very important to choose someone who is able to make calm, informed decisions, preferably someone who has a good understanding of your health and maybe your particular health condition. You should always discuss with the agent and your alternate agents, people you choose to appoint, if your first agent is unable, because they can take ill or pass before you, of course. You should always appoint an alternate or two alternates. But it's very important that you discuss with that agent what your thoughts are about health care, if you should become unconscious or unable to make decisions, or just if you should have dementia, or if you should be in a condition where you're soon to die.
You know, these days, when you got so many people are getting this kind of advanced or early onset of Alzheimer's, is sort of a scary thing. So 55 is not too young to start doing this kind of thing. What about a living? What is a living will? And we'll come back to healthcare proxy in a minute. I just wanted to get through the 5 right here, and then we can come back in more detail.
Sure. A living will is a statement specifically concerning your wishes at the end of your life. So it's a companion document to the healthcare proxy. In many states, it's one document. Where I practice, it's 2 separate documents. So you appoint an agent. If the agent knows your feelings about being kept alive by extraordinary means at the end of your life, or if perhaps you choose not to be kept alive by extraordinary means, and we'll talk more about that, then the proxy person can theoretically make those decisions for you. But a living will is a separate statement of your wishes concerning what treatment you might want or what treatment you want to withhold, you want to be withheld if you are dying and there is no expectation of recovery. Things like feeding tubes or mechanical respiration or even intravenous. So it's really a directive in which many people choose to say, I wish to die naturally if, in fact, my death is imminent and there's very, very little chance that I will recover.
All right. And you're saying that the healthcare proxy and the living will can be sometimes combined in one document, but most of the time they're a separate document.
I don't know about in most states, I haven't counted, but in some states they are one document, and in some states they are 2 separate documents. Because the healthcare proxy is much broader. A healthcare proxy agent can make decisions at any time during your life where you might be unable to make those decisions. Even if you're, temporarily were in an accident and you were in so much pain that you couldn't think clearly, you could say, look, talk to my proxy. I can't decide what treatment I need among these choices or which hospital I should go to get these treatment. Your healthcare proxy can step into your shoes and make those decisions for you.
All right. Now, the power of attorney, everybody everybody knows what a power of attorney is, but this is kind of an end-of-life power of attorney, a little different than the one that people usually will get somebody to help them with their affairs. An end-of-life power of attorney, a little different than the regular one, the general power of attorney?
Absolutely. I think there's some natural confusion because of the names of the documents. So a healthcare proxy and a living will have to do with your health and decisions about how your body should be treated. A power of attorney, or a general power of attorney, or what's often called a general durable power of attorney, has to do with appointing an agent concerning your property and your rights. So it allows anyone that you choose to stand in your shoes, put your shoes on, and go to the bank to take money out of the bank for your use, to transfer your real estate, to apply for government benefits if you need them, to deal with your billing, to sign your checks, to actually act as if they were you in most circumstances. And you can limit those circumstances, or you can make them very broad, so that your business affairs and your rights can be protected if you are unable to act for yourself. And it might simply be because you're stuck out of the country, or you're in a temporary situation where you can't attend to things that you need to attend to. You're in the house, someone needs to go to the bank, someone needs to go to a meeting to transfer property or some transaction. You can send your agent with that document. It differs from state to state. It's a very, very powerful document, and it's extremely important that anyone who has a competent person whom they really trust give that agency to someone and to an alternate so that they can carry on your affairs if you're unable to carry them on for any reason.
Well, now, this power of attorney, a lot of people, and you mentioned this in your book, and I think it's a natural human characteristic to not want to give up the power over their affairs until they absolutely have to. So when somebody has a power of attorney like that, is it written or drafted in such a way that this power of attorney doesn't kick in unless they're declared incompetent or they are incompetent? How does that work so that a person can say, listen, I want you to have my power of attorney, I want you to handle my affairs if I'm no longer able to do so, but I don't want you or this person being able to act as a power of attorney unless that day comes or until that day comes?
There are many ways to limit the agency that you give under a power of attorney or qualify the power that you give. So you can certainly put language in the power of attorney that says, until I'm declared incompetent by two physicians who are familiar with my health condition, this power of attorney may not be used.
So that's what you put. That's what you put in your POAs.
Actually, we do not generally put that in our POAs unless there's a particular concern about the agent. And these forms do differ from state to state. There is a sample form in our book at the back of the New York State form. There are other ways to protect yourself against a rogue agent. For example, in some states you can appoint a monitor. Now, I always say if you have to appoint a monitor, then you're choosing the wrong agent, right?
Right.
But there is a way to have someone look over the shoulder of the agent. Again, it's vital to choose the most trustworthy, competent person in your menu of friends and loved ones to take on this job. You can choose two people if you think you have two kids and they're not going to treat each other fairly, or there's some distrust that you have. You might say, okay, you guys have to act together. You can choose one person at a time. You can choose two people to act together. Of course, if you choose two agents in any of these situations, you always risk the possibility that they will not get along, and then you haven't really accomplished what you're trying to accomplish. So it is a document not without risks, but it is extremely powerful and critical to have in situations in which you are stuck and all your money's in the bank account and you become ill very suddenly, and now you're in the hospital and no one can pay your rent if no one's on your bank account. No one can pay your heating bills. We've seen situations where clients are completely incapacitated and their money is frozen and no one can access it.
I see. So in this particular case, you're not incompetent, but you're unable to do it. So the power of attorney should be able to kick in, without there being an actual declaration of incompetence. So you're laying there in the hospital. You're not incompetent. You're able to govern your affairs. You're just not able to get around to go do it.
Exactly. So my preference with my clients is to say, if you trust this person, don't qualify the power, because you don't know when it will be needed.
Yeah.
Some people insist that it not be used until they're incompetent, but I have a situation right now. A client of mine took ill. He's in a hospital. He's now in rehab. He might be there for 2 or 3 months. He didn't take any of his checkbooks. He's not looking at his billing. He has a power of attorney in place, so that person can go in and sign his checks and take care of his affairs. We have situations where people's, homes have gone into REM because they haven't paid their real estate taxes, or they just fall apart and they're not able to continue. I recently had a case where a gentleman who had a stroke, and he was competent, but he was borderline competent, was being taken care of by his healthy wife for many years, and they were doing fine. All their kids lived out of state. She died suddenly, and all of a sudden he did not have the ability to write checks, go to the bank, express himself, and he was stuck in his apartment without the ability to pay for his own care. He had the money, he just couldn't get at the money because the power of attorney that he thought he had drafted correctly was completely drafted incorrectly. Somebody pulled it off the web, they signed it, and it was not valid. So without this very essential document, people often find themselves stuck without access to their assets or without the ability to transfer their assets so they might become eligible for benefits that they desperately need.
Well, if you've just joined us, I'm with Joanne Seminara, and she's an attorney from New York and New Jersey. She's been practicing law for 3 decades, and she's the author of 5 at 55, and we've been talking about these essential documents that anybody 55 years of age and older absolutely have to have. And I think that you just mentioned an answer to one of my questions that I was going to ask you. I didn't know when was the appropriate time, but in my experience, so many people, they don't want to spend any money on these things. They come in, how much is a will going to cost me? And they want to spend $50 or less and get a will, and they want to have all these things done, and they want a power of attorney. And so what ends up happening is they don't want to spend any money on an attorney, so they go to LegalZoom or they go to one of these kits off the web and say, gee, I'm going to do it myself and do a will, and I'm going to write it all up. And you're telling me that, and you mentioned in your book that that's kind of a recipe for disaster. And I'm not saying this on my show because we want to have an elder law full employment plug here, but it is scary when people try to. You pick up you turn on the TV and there's the former O.J. Simpson lawyer, what's his name, Robert Shapiro, and he's advertising for LegalZoom and all this kind of stuff. These documents, this do-it-yourself stuff. You recommend against that?
We do, and we see the effects of that process because many people take the forms off the internet or buy them from a service, and then they proceed to fill them out the way they think they should fill them out. I have a case right now in which someone filled out a will and they didn't appoint an alternate executor. So the executor who was named in the will passed away before the decedent, and now I have different people in the family jockeying to become the administrator of this estate. That's likely to tie up this estate for years, and in the meantime, there's real estate to care for, there are bills to be paid, and we're all tied up deciding, or maybe even fighting over, who should be in charge of an estate when someone just failed to do something simple like, you look at your daughter, you say she's healthy, she's 35 years old, what could go wrong? And you just don't anticipate the tragedies that sometimes befall us. I mean, we see them in our office every day. We see people come in very stressful conditions, needing to make decisions about health care or end-of-life decisions, or coming in on behalf of an elderly parent who's no longer competent, and I'll say, where is she? Where is this parent? And they'll say, she's not really going to be able to meet with you because she's not going to know where she is. She's not going to understand anything that you're saying. And I say, I can't represent her unless I know you represent her. Do you have a power of attorney showing that you are her agent? And if they do not, and she is not able to sign a power of attorney and appoint an agent and be clear about who she wants to be in charge and know, who her family members are and what she owns, then we're not going to be able to do that document. And very often we're going to end up in court appointing a guardian so that this person can get care and use his or her own assets to get that care.
Well, that's extremely difficult to predict the longevity of somebody that, you can pick somebody that's 20, 30 years younger than you to be the executor, and
yes.
they meet an untimely death, so you always recommend...
two alternates at least.
Two alternates, so really three potential executors, one,
correct.
Then two, then three.
Absolutely, and choose...
I'm sure there's some people out there saying, you know what, I love what you're saying, but I can't think of three people in the world that I trust. Sorry. And that is, and that power of attorney thing too. You're putting an enormous amount of trust in somebody. Well, let's move on from that, because that does, but you're unequivocal about, please do not use do-it-yourself will kits. Do not use LegalZoom or one of these do-it-yourself off-the-web kind of things. But so often people just don't want to spend the money. What can somebody expect to pay? I'm going to move on to number 5, because 5 at 55, and for those of you who've just joined us, I'm with Joanne Seminara. We're talking about the 5 essential documents that you need if you're 55 years of age or older. And the first is the will, the second is the healthcare proxy, and third is the living will. And the fourth is a power of attorney for somebody to manage your affairs if you become incapable of doing it yourself. And then the fifth you mentioned is a digital diary. And like I said, we can come back and go into detail about some of these 5, but what is it? Many people are familiar with the first 4. Everybody's heard of a power of attorney and a will, and we use advanced medical directives here in Virginia, which I think to some extent encompass both the healthcare proxy and the living will. So I think it's standard for us to do a will, advanced medical directive, and a power of attorney. If somebody comes into my law office, that's what we'll prepare. But this digital diary is something kind of new. What is that? What's the purpose of it? And that kind of sounds kind of cool, a digital diary. What's that?
Well, we call it the new kid on the block in terms of legal documents, planning documents. It's a document, it's a form on which you write down all the websites on which you have a digital presence. So that could be Facebook, LinkedIn, PayPal. It could have all your banking, all the banks that you may do bill paying from, and all the passwords and the account numbers. And so if you become incapacitated, we find a lot of our clients have that information in digital form, and if they haven't provided us or their loved ones with a list of their assets, the best way to get it might be to have something, a piece of paper, a digital diary, that has all the passwords and all the forums on which you have a digital presence on it. And so we encourage our clients to leave that information not on the computer, but maybe in a desk drawer. Change it as you change your passwords, which we're always encouraged to do, because often that's where the information is, or that's the best way to get information about someone's assets. And then, the ability to close down some of their social media accounts. There are millions of presences on Facebook of people who have passed away, and sometimes we get messages from, those birthday clock messages from people who have deceased that could be painful for the family. Many people keep all their photos online, family heirloom photos. They've downloaded them all, and if they're precious things that speak to a person's legacy, and if you can't access those photos, it can be a loss for the family. So we encourage people now to fill out this digital diary, which is also attached as an appendix document to our book, just to have them think about passing on that information with some direction about closing those accounts and closing those presences on the web so that they don't continue indefinitely. There is the opportunity for for fraud, for people to impersonate someone who is deceased and get access to their bank records. I mean, we've all heard those stories, but it's best to be protected, and most people don't want to continue on the web, have their presence continue after they're passed away. So we're going
to take a short break here, Joanne, and we'll come back on this digital diary. When we come back, I'm with Joanne Seminara. We're talking about 5 essential documents you need at 55. We'll be right back after this short break.
Wildfire in the Lake County area, about 175 miles northwest, has killed 3 people, destroyed nearly 600 homes, and burned hundreds of other structures. A 21-year-old Arizona landscaper is expected to make an initial court appearance on Saturday in connection with a series of shootings at cars on Phoenix area freeways. Police arrested Leslie Merritt Jr. last night after they say a gun he owns has been linked to 4 of the 11 vehicles that have been hit by gunfire. And the German Navy's rescued almost 400 people from a wooden boat on the Mediterranean off the coast of Libya. Thousands of migrants drowning this year while trying to cross the Mediterranean from Libya. This is SRN News.
It's one of the biggest gospel music festivals on the East Coast, and this year it features the biggest lineup ever. The Virginia Beach Gospel Music Festival, October 8th through 10 at the Sandler Center for the Performing Arts, with Guy Penrod, the Booth Brothers, the Triumphant Quartet, Mark Lowry, Daly and Vincent, Brian Free and Assurance, the Martins, Jeff and Sherry Easter, the Hoppers, the Irwins, comedian Tim Lovelace, the Penny Loafers, and more. The Virginia Beach Gospel Music Festival, October 8th through the 10th at the Sandler Center for the Performing Arts. Tickets are available now. By phone at 877-392-9710. That's 877-392-9710. Online at imcconcerts.com. imcconcerts.com. It's a tsunami of gospel music hitting the East Coast. The Virginia Beach Gospel Music Festival. It's 3 days and 5 big sessions at the Sandler Center for the Performing Arts. For more information, go to virginiabeachgospelmusicfest.com.
The place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their 2 locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today.
Leaky faucet, refinishing old countertops? Hey, Gary Sullivan here. Perhaps you're restaining a deck or painting your living room. Whatever it is, let me help. I'm here to give you the tips you need to finish those pesky projects you've been putting off. If you're restaining, I have a tip for that. Can't get the paint off the hardwood floors? Got a tip for that too. I'm here to make sure that $5 repair doesn't turn into a $500 repair. Join me right here every weekend.
Saturdays at noon, Sundays at 9 a.m. on AM 1650 WHKT, The Answer.
Hi, this is Greg Picaveras, inviting you to join me for Sports Scene live each Wednesday from noon to 1, right here on News Talk 1650 and TuneIn.com by typing WHKT in the search box. Excellent guests and interaction at Greg Bick on Twitter, all powered by HamptonRoadsOnlineMall.com. Sports Scene each Wednesday from noon to 1, right here on News Talk 1650.
Are you prepared to defend yourself and your family against any threat? Veteran-owned and operated One Shot Trading Post is ready to make sure that you are. Continuing training and classes on defense, survival, and weapons. Full gunsmithing services, special orders and financing available with military discounts. $15 transfers, and One Shot Trading Post is always looking to buy, sell, or trade. Located at 4366 Holland Road at South Plaza Trail, make sure that you're ready for anything at One Shot Trading Post, 463-5893, OneShotTradingPost.com.
Mark Levin here, reminding you to tune in every evening, 6 to 9 p.m. for some no-holds-barred opinions and discussion of what's happening. If you don't have an opinion, don't worry. I'll give you one. So you have no excuses not to join the Mark Levin Show, Monday through Friday, 6 to 9 p.m. on your source for conservative talk radio, AM 1650 WHKT. Now, we have some real problems in our country, and they won't get any better by themselves. Be a part of the solution. Mark Levin, weekdays 6 to 9 on K-Talk 1650.
Mi Hogar is your restaurant for the finest Mexican cuisine in Hampton Roads. At Mi Hogar, everything is prepared fresh in a casual atmosphere. Enjoy traditional favorites such as quesadillas, tacos, burritos, and fajitas, as well as refreshing beverages. Mi Hogar has 2 locations, 4201 Granby Street in Norfolk and 801 North Battlefield Boulevard in Chesapeake. Call ahead at 640-7705. Acme Hogar, there is something for everyone.
Welcome back to the last 30 minutes of our Justice for All show. I'm George Yates, and if you've just joined us this afternoon, I'm here every Saturday from 2 to 3, and I try to deconstruct what the experts say about various subjects usually in the legal world, but we get far afield these days. And today I'm kind of in an area a little bit outside of my expertise. I've been mostly a trial lawyer for the last 25 years and stuff, but we do get in elder law issues from time to time because it does come up even from a personal standpoint. We've had a couple of shows devoted to it so far. And I'm here today with Joanne Seminara, and she's been with us the last 30 minutes. She wrote a book called 5 at 55. And your co-authors, I'm going to give them a little bit of credit here, Joanne.
Sure.
Judith Grimaldi, she's your law partner, I guess. And Pierre Lehoux is your husband. And
yes.
And I see that he's also gets some credit in your book. And if those of you just joined us, you might want to pick up a copy of this 5 at 55. Where can we get a copy of this book here if you've just joined us?
You can get it on Amazon.com.
All right.
And you can also get it at Barnes & Noble's. You can get that on the web or in most Barnes & Noble's bookstores, as well as many other independent bookstores. Okay,
great. And then if you all have just joined us or you haven't heard the show before, you can always go to my website at ghylaw.com, and you can always go to our YouTube channel as well. And I do program notes every week. Sometimes it takes till the end of the week before I get the program notes up. Sometimes I miss it and don't get them up for a couple of weeks. But I try to get the information. Joanne Seminara, you practice law in New York, is that right? I see you're of counsel to the firm now, right, Joanne? Have you
yes,
kind of
I am.
semi-retired these days?
Actually, I'm not retired at all, but that's my status with the firm. And
all right.
It's working well for me.
So you're working pretty much full-time then as an elder law attorney?
Absolutely, full-time. Elder law and estate planning, estate administration. So sometimes we're cleaning up the estates, helping administer them. Often they're tension-filled and litigious because the correct documents were not put in place or the documents were not clear.
Wow.
And so we see, so just going back to why we wrote the book, my husband Pierre is a writer, and virtually every evening I'll come home with another story, a very sad story of a family who has not planned and needs to transfer assets to typically access governmental benefits, people with Alzheimer's, people who can no longer live in their homes, people who can't live in their homes without some assistance which they don't have the assets to pay for, or they don't wish to spend themselves down to a very minimum income and assets so that they will qualify. We see families who have to make healthcare decisions who don't have the documents with which to do that, and then are left to maybe squabbling over whether mom should get this treatment or that treatment, whether she should be allowed to die naturally or kept on life support. I think those are the most heart-wrenching situations that we see. We see blended families where there might be a second marriage and the husband does not agree with the children of the first marriage about decisions about a loved one who needs someone to take over and bring in help or be left to die naturally. There's just a lot of family strife and emotion around issues that could be much more easily resolved. Never easy issues, but could be resolved in a straightforward manner if each of us appoints the person that we want to make those decisions for us when the unexpected happens.
So when did you write this book?
We wrote the book we published it in June, and I'd say it took us about a year to pull all the stories together. Judy and I pulled all the stories together, and then Pierre helped us bring it all together and found a publisher for us. We're very happy that Quill Driver Books has published this book, and we hope to write a book for lay people and demonstrate through the stories that are in the book why it's important to have these documents. We did not intend, and as lawyers, we write a little differently than the average person. We write in legalese. We write documents that nobody wants to read. But we wanted to write a book that is clear and tells through stories why each of these documents is important. And our goal was not so much to sell books, but to start a public conversation about why you should not procrastinate and why we will have, less strife and less stress in our families and more good feeling after someone passes if they're clear about what they want done and our loved ones are not there fighting over who mommy wanted to have this or that. We want our clients to be very clear and put the people in place who will make those decisions or tell us exactly how you want to be treated and how your assets should be distributed after you pass away.
So this book, it's not a do-it-yourself book. It's not a book that you're supposed to go buy so that you can draft your own will, healthcare proxy, power of attorney, and digital diary. It is
not at all
really meant to just, I guess, educate people on the seriousness of the issues, the problems that can happen, so it draws attention to it so they go out and get an attorney to help them with these documents.
Absolutely, and we often compare it to, you asked me earlier about what does it cost. So,
right. Because a lot of people say, gee, I don't want to spend $1,000 now, or I don't want to go pay a lawyer for all this time, and I'd rather go to LegalZoom and do it for, free, or, these. So tell us how, so go ahead. I'm interrupting you, but
that's fine.
People all want to save money, don't they?
We all want to save money, right? And we all have car insurance if we drive a car. We own a home. We have homeowners insurance. Now, more of us have health insurance. This is part of our budget. We pay for it. We need to pay for it. And we pay for it every year. And most of us pay thousands of dollars for all that type of insurance every year. Sometimes more than $10,000 when you add all the insurance that we might pay for. I would say the cost of doing these documents is probably less than the cost of insurance for most people. And you do it once. That's not to say you shouldn't review it every 5 years or so to make sure the people that you've put in place are still able to carry out your wishes, that you still have the trust that you had when you made those decisions in those people. Sometimes life situations change, people pass, people get remarried, people have children. Children grow up, and you say, I want Johnny, he's a brilliant lawyer, I want him to be my executor now. Things change, but the point is, we protect ourselves in so many different ways in society if we can afford to do it, and we often procrastinate and do not prepare 5 essential documents that will protect us, protect all of that, all that we've worked for, all of the family and friend relationships that we have in our life, protect our loved ones, protect some of those assets by making sure they're available to the next generation or to those who we want to have them. And we fail to do these documents, which cost far less. So prices are different from state to state and city and country, but for several $100s, you can prepare all of the advance directives. There are additional advance directives that are special to New York State, like there's something called an agency to appoint to dispose of your remains. That's a separate New York State form. So typically we do 5 or 6 of these documents for $500 or $600. It's different in different locations, but we're talking hundreds of dollars to protect your decision making, your physical integrity in terms of how decisions are going to be made about your body, and your who's going to pay those bills if you can't do it, who's going to apply for Medicare or Medicaid if you need to apply for Medicaid and get you the help that you need. And
that's peace of mind. That doesn't seem like a whole lot of money to spend.
No, I mean, a will is a separate charge. The cost of a will vary depending on what you want to do in the will. I mean, you may want to set up a trust within your will for someone in your family.
What does someone do? I've got a specific question. A client came in the other day. I don't do a lot of this. I think we see this kind of thing a lot. You do talk about blended families. What do you recommend? And you say you got a husband and wife both come in, and she's got 2 kids from a previous marriage, and he's got 2 kids from a previous marriage. They both want to leave everything to the other spouse, but they want to make sure that if the other spouse passes, let's say 5 years, let's say 5 years apart, that their children are protected. So how do you write that in a will? To protect the children that, obviously, let's say you get the question, right?
Yes, I do. Well, one way to do that, depending on the amount of assets that we're talking about, is to create a trust for the surviving spouse, where the surviving spouse gets all the income that might be generated by particular assets, and might get to use up a certain amount of those assets for his or her remaining life, and then the balance go to the children it's intended to go to. So there's ways to limit what goes to the surviving spouse. You could consider doing a prenuptial agreement or a postnuptial agreement to spell out the rights of the surviving spouse. You could segregate certain funds, like make the surviving spouse the beneficiary on a pension or an IRA or a 401k, and separate out enough for the surviving spouse to have a generous amount of income. Or you could put a third party who's not a member of your family and someone you trust to make good decisions about the needs of your surviving spouse, and make them the trustee of this trust. So you're confident. Choose someone you're confident won't favor one party over the other. I want my husband to have enough, but I also want to be very prudent so that my children get that remainder when they pass away.
What if the what if the asset is probably just something no larger than, let's say, $500,000, maybe a condo, and maybe a $400,000 condo that's paid for, and or maybe some other assets that are too hard to kind of divvy up, into income producing type stuff like that.
Well, there are ways to have people make covenants or contracts with each other to make reciprocal wills, so that if I leave everything to my husband and we both have kids, that he's making a promise through a separate contract or through making some type of reciprocal will that he won't change his will, and then it's going to go to all of our children, or that half's going to go to my children, half's going to go to his children.
So actually, as part
That's
of...
complicated. That's complicated. I'm not sure it would be my first way to go.
Right.
I like the trust idea better, but there are ways to do that. If it's a large estate, then the trust option might be a better one. You can give the trustee the ability to invade the principal if needed, to give all the income. You can even say that the spouse has to have a maximum amount of income every year, so she or he has certain rights, and they can't be cheated out of a reasonable sum every year. And then you can provide that at the death of the spouse, the balance gets distributed this way. You have to be careful that you're not interfering with spousal rights of election. Don't want to get too complicated, but in most states, a spouse has a right to a certain share of his or her spouse's estate. And if I leave my spouse out, he can say, wait a minute, after I pass, I didn't get my share that I'm allowed to under the statute. So these are some of the issues why you need to speak to a professional. Everyone's family is unique. Some of us may have disabled children. Some of us may have persons in who we want to favor that are not going to be able to handle the money when they get it, just because they're spendthrift, or they have substance abuse issues, or they're just don't have good judgment around money. We often put in our wills things called optional supplemental needs trusts for anyone any one of our beneficiaries who might not qualify for government benefits if they get a large bequest. But there's ways to have those assets used for that person and not disturb any benefits he or she might be eligible for at the time of the death of the will maker.
When you described this digital diary, and I think we were talking about that right before the break, I wanted to come back to that a little bit. That's kind of new. Well, the name digital diary sort of gives this connotation that you're actually doing something every day as part of this. I mean, that's not what you're talking about. You're talking about just leaving behind a record of passwords and information regarding your various accounts, whether that's your Wells Fargo bank account, your Facebook passwords, these kinds of things. Is that right? And it's not really, when you say digital diary, you don't mean that. You mean just basically a list that's updated. Because passwords change all the time. I mean, it seems like every time I change passwords all the time because I forget my password. It says, forgot your password? Yeah, I forgot it because I got so many. And then they say, well, you have to change it now because you've forgotten it. Right. And so they change all the time, and then I can't remember what I changed it to. So I change it again. I've got so many passwords now and so many email accounts. I can't remember which one is which. I can't even keep track of my own digital diary, much less try to have somebody else track it. How in the world are we going to keep track of that for somebody later on to come along and do that?
Well, the idea is to make a good habit of, making a record every time you change your password. So
good idea.
And not to keep it on your computer because that's going to have its own password. I know in my practice, my password changes automatically. They prompt me, okay, what's your new password? Because of all of our client records have to remain secure. So I typically call my husband and say, that list I have by my side of my desk, I just changed my password, or just remind someone else that you've done it, that you need to do it, so that you have another, a reminder, and then I come home and change the sheet that I have at home in my desk. We're going to have to develop good habits around that if we're going to leave our executors the ability, or our power of attorney agents the ability, to keep track of our assets and be able to get into our computers. We had a client who was disabled. He lived, he didn't get out much, so he did all his communications and bill paying and had all his photographic records and music collections. Everything was on the computer. And he was pretty diligent about keeping the passwords, but he didn't change the last password change. He didn't record the last password change. My partner was the executor of that estate, and she had to pay thousands of dollars to a computer professional to hack that computer so she could find out things like, what his house expenses were, so she could take those expenses off his tax return, and what charitable gifts he had made, and everything was on there, and all the, the bank accounts. So he didn't have a paper trail, and we couldn't get in. And it took several months for us to get in and find out how we could access those records and represent his estate.
So what are some of the horror stories that, I think that's what got you? If you just joined us, I'm with Joanne Seminara. I've got a couple of questions here, Joanne. First of all, how did you get into being an elder law attorney? Because I think this is definitely a calling of yours and a passion, and you've been involved in this kind of thing for many years. I see you've been a member of the community board, 10 for 18 years. You've been, you're basically a volunteer in so many things. So you're very passionate about this subject. And you wrote this book with your husband and your law partner because you saw so many problems with people who died either without wills or with wills that had been poorly written. Tell us some of the, let's say, if you got a top five, if you will, of problems that can happen and why people should not do it themselves in trying to execute these documents.
Well, to your first point, it's immensely satisfying practice because you can see people come in to our office in extremely distressed or tense, or they don't really understand what going to a lawyer is all about, and they know they have to do something when they're not sure what it is, and we get a lot of satisfaction out of breaking down the decision-making and helping people to come to decision-making around some of these issues. A lot of the procrastination occurs because people just don't want to face that they have to do it. They don't want to choose Johnny over.
They can't make up their mind.
They don't want to choose Johnny or Mary. They know that their oldest child maybe is not the best person to put in charge of these things. They don't want to hurt his feelings. They want to make sure the child that lives with them has a place to live after they die. But they don't want to, there's one issue after the other. People are holding them very close to their heart, and they're festering in there. And we help them very compassionately and very personally and very confidentially. Let's sit in this room for hours sometimes, and let's just see where the issues are. Sometimes it takes several meetings. Let's figure out what's best for you, and maybe there's a way to address those concerns. If you can't put your eldest child as your power of attorney agent because you're concerned about his decision-making regarding money, then maybe he's a person to be on your healthcare proxy. Maybe we can give him another role that is just as important, if not more important. There's a way to get through this decision-making process that we take great pride in helping people through. And it does, we dispel the people's notion about what it is to go to a lawyer, and we literally see the tension ease as we get into these things and say, there's a way to manage leaving your spouse enough and still taking care of your children from the first marriage. There's a way, there's a path forward, and we will find it for you. And then when people pass, and we often handle their estates, we see the good fruits of our labor and their decision-making with us, and we're able to really settle things and take the stress away. We like to see people plan. I didn't want to plan for myself. It's just not something I want to face. But I know that I don't want my children to wait months or years trying to figure out what I wanted while, money is just flying out the window and people can't have an estate settled. So there's lots.
And you've seen these problems because of like you said, you've told the stories already. The executor that dies, and now or people that die when people die without a will, that creates all kinds of problems.
I've seen homes where the pipes are frozen because no one paid the gas bill after someone died because no one could be appointed and get access to the assets. And they weren't, or no one was willing to step up and say, okay, I'll lend the estate $10,000. Someone's already paid for the funeral bill. Now we're saying, now I have a broken boiler, it's the middle of the winter, I have water pouring in this house, and there's no one authorized to access assets to take care of the situation. So I think when people think about planning, you've got to get them to think in advance of what will happen. And we don't want to scare them into it, but we want to encourage them to make life easier for their loved ones by knowing how it's going to work. If you've appointed someone or you've created, instead of a will, and we could talk about this if there's time, a trust, things can happen a lot more quickly and a lot more seamlessly, and your affairs can come into order much more easily than if you completely fail to plan. And I can't tell you which document is more important, but the healthcare proxy and the power of attorney are so critical. I've had people use that power of attorney to create trust when, have the agent create the trust when they have already become incompetent and they can't change their will. The power of attorney can include the ability to create trust.
Ah, that's cool. Mm-hmm.
And so if you have someone that you trust implicitly, and they know what your assets, they know what your decision-making is, that power of attorney can accomplish so much in terms of what you want to leave and how decisions will be made for you. And then one more thing about, we talked about the danger of a power of attorney.
We only have about a minute, so...
go rogue, but they are only authorized to act in your best interest in keeping with your wishes. It's not like you give this document away and say, run with it. It's for the benefit of the person who gives it, as are all these documents.
Yeah, the person with the power of attorney still has a fiduciary duty and can't just squander the assets, or else they're going to face legal action themselves.
Exactly. So it's not like the law does not have protections.
We've only got about a minute. What I'd like to do here then is wrap it up with you, Joanne, and I know that we could go a lot longer, but how do people get a hold of Joanne Seminara if they want more information about you and what you can do?
Well, we do have a website. It's called www.5at55.com, www.5at55.com. We've created a national campaign around this
5 at 55. So you can just go www.5at55.com and get a lot of the stuff that we've talked about today. And you are Joanne.
There's many attorneys on there. We formed a national campaign through participating attorneys so that people in different states can speak to attorneys who are qualified to prepare these documents, and they're all very highly recommended professionals.
Great. Well, then we're going to have to leave it there. Then we got about a minute to go. I'd like to thank Joanne Seminara for coming on the show today.
My pleasure.
All right,
George.
Thank you so much.
Thank you
Okay,
all.
and we're gonna include that 5at55.com on our program notes on ghylaw.com. That's my website, as well as on our YouTube channel. And we're gonna leave it at that. And thank you for Joanne. That's the name of the book is 5 at 55. Join us next Saturday again for another edition of Justice for All. I'm George Yates, and if you have any questions about this show or any other show, you can go to my website at ghylaw.com or call me at 491-8800. Have a great day. Bye.